after 6 here. We may have a few more people trail in, but I think we're going to go ahead and get started. If you haven't grabbed a snack, please feel free to do so. And we'll leave those out, so you are welcome to snack a little more afterwards as well. I want to thank our Grace Dietary staff. They always do an awesome job for us. We eat well around here. For those who don't know me, I'm Melissa Porter. I'm the VP of Sales and Marketing here at Wesbury, which is a fancy way of saying that I'm in charge of making sure we get the word out on who we are and what we do. And I'm blessed to have a great team, and they're all here tonight. Andy Clausen is in the back of the room here. He's our Director of Communications, and he is videotaping this. So if you need to watch it again, our hope is to have it on our website. You'll be able to watch it via YouTube on our website. So greeting you coming in the door was Melissa Cornwell. She's waving at you if you can see her. Melissa is my partner in crime here, giving a lot of tours and sharing a lot of the information about Wesbury. And Darlene Means, to her right, is our creative director, and she designs all the lovely things that you see, the pieces that come in the mail and the brochures and such. So we're thrilled to have you here. If you have any questions after the event, I'll be hanging around, as will Melissa, and we're happy to answer any questions that you have. But we're here tonight because Kemp Scales knows how to draw a crowd, I see. He and I are both marveling at the number of people. We actually have this room full to fire capacity. We couldn't take another reservation, so we're glad you called when you did. So I will introduce Kemp, and we'll let him take it away from here. Kemp is a certified elder law attorney. He owns Scales Law Offices. He concentrates his practice on the legal needs of seniors, disabled, estate and long-term care planning, special needs trusts, veterans benefits, and estate administration. He is one of only 39 certified elder law attorneys in Pennsylvania, so pretty impressive. He's a frequent speaker on topics related to elder law, and he serves on the faculty for Pennsylvania Bar Institute, provides continuing education for attorneys. He also writes the bi-monthly Scales Elder Law newsletter, which I'm sure if they wanted to get that, there'd be a way. He'll think on that one. But he also has a monthly column on elder law issues in the Tri-State Senior News, which you can pick up around the region. So you can look for more information from him there. So no further ado, Kemp, thanks for coming.
Okay, we've got an hour, basically, so I want to talk for about half an hour about what I think you're here to listen, and then I can take questions for a while after that. I'm not able, of course, to be talking about individual particular situations, but I can certainly talk about topics that you'd like to hear. So, the topic of tonight's talk is protecting assets. When you're talking about protecting assets, you say, well, what's the risk that you're concerned about? Well, it's paying for long-term nursing care. In this country, we don't have a universal health care system. We do have Medicare, which is a very important social and health insurance program for seniors and people with disabilities. But Medicare was never designed to pay for long-term care. So when we come to that, there's one government program that will pay for long-term care once you qualify is Medicaid. But the catch is that you have to be impoverished first. So what I'm going to talk about, though, is that the Medicaid rules permit folks, seniors, to protect a substantial portion of your life savings that would otherwise be at risk of all being spent down before you could be eligible for Medicaid. However, I've been doing this for 17 years. Like Melissa said, I've been writing a monthly article in the Senior News for 16 years. And I had to pause on that newsletter. I haven't been updating that recently, but with enough demand, we'll get it back in circulation. But I find that the people that are clients that we see coming in to talk to us, or children concerned about a parent in a nursing home, have the same misunderstandings and misconceptions about Medicaid as they did, all along. So I guess the purpose of this is to try to let you know, that's the key takeaway point here, is number one, even in a crisis situation, when I mean someone is already in a nursing home, it's still possible to protect roughly half of what's otherwise at risk of being spent down if this is a single person. And 70 to 80% of what's at risk if it's a married couple and one spouse is in the nursing home. So we do a lot of this work when people call and say, Mom's in the hospital and they say she has to go to a nursing home next week. Is there anything we can do? Yes, we can, almost always. The principal reason for people to call that we can't help, and this is sort of the second takeaway from this evening, is, let's say Mom's in the nursing home. Well, in the reception of my assistant there at the office, taking the phone, will say, well, is your mother competent, mentally competent? If not, which of course is not unusual in a nursing home setting, the next question is, well, does she have a power of attorney? Sometimes yes, sometimes no. If they say, oh yes, she does, and my brother and I are her agents, the next question will say is, does that power of attorney include an unlimited gifting authority? I'll get into what that means, but, daughter says, I don't know. Well, fax it over to us. Let us see it. If it doesn't, so if Mom's clearly incapacitated, so she can't be making gifts or signing legal documents or anything like that, and her power of attorney does not include an unlimited gifting authority, there may not be any reason to even have a meeting, because that's the one subset of the people who call most often if we can't help. And the reason is this: the only way to protect assets, I'll talk in a minute about the house, which is sort of a different case, but other than the house, the only way to protect assets are to get them out of your name and control. Well, if Mom is not competent, she can't make gifts knowingly, then it depends upon whether the agent under the power of attorney has the authority, the legal right, to take money and property out of Mom's name and put it over in the children's name. If not, again, you can't do anything. So one of the important things is, whenever I meet with clients, I'm always going over their power of attorney, and I mention, is there a risk in giving an agent? I mean, think about this. You've got your, let's say, son and daughter. Now, I'm sort of talking in the context of a single person right now, but we'll talk about a married couple in a minute. But, a son or daughter who are your agents. And you might think, well, wait a minute. They have the right to take money and property out of my name and control without limitation as to amount, up to everything? And remember, they're going to be using this when you're at your most vulnerable, when you're incapacitated. You can't take care of yourself. You think, well, I thought the purpose of this was for somebody to care for me. Why are you going to be in a hurry to start grabbing everything as soon as I'm incapacitated? Well, the purpose is, or the point is that, again, there's no way to protect your assets without getting them out of your name. So that's it. That's it. There are various things I can talk about, and we're going to run out of time before we even know it. I can talk about a married couple protection. I can talk about protecting the house. In fact, I'll do those right now, and then we'll see if people have other ideas. For a couple, right now, and this has been true for, the 17 years that I've been doing this work, and especially true in the last 6 or 7 years after a couple of court decisions came down making it very clear from the challenge that this is exactly what the Medicaid law permits. Let's say husband is in the nursing home, wife is living at home. She's known in the Medicaid jargon as the community spouse. She's living in the community, not in the institutional setting. We can have the wife use the money, the portion of the money that's otherwise going to be spent down on nursing care before Medicaid eligibility, and purchase an immediate annuity for her benefit. Now, just a real quick note here. Almost anyone who comes into the office who have annuities as part of their bank accounts and CDs and mutual funds, maybe annuities, those are not what we're talking about now. Those are just tax-deferred annuities. They're like bank accounts. For Medicaid purposes, they're just, has to be spent down just like everything else. An immediate annuity is a contract purchased from an insurance company, and let's say there's going to be $75,000 in the annuity. You need to tell the company what's the payment term? How many years, how many months is it going to pay out to the wife? Let's say it's for 3 years, 36 months. Then they'll come back and say, we will pay, I don't know what it turns out to be, let's say $1,314.75 every month for 3 years, and whatever it is. So in other words, the entire $75,000 is paid back. What we're doing in that case, and I know it sounds a little odd, it's sort of like a shell game or something, but in fact, this is exactly what the Medicaid law permits. Taking assets that are countable and would otherwise have to be paid out at the rate of $8, $9, $10, up in here at $12,000, $14,000 a month until it's all gone, taking that and converting it into a stream of income for the community spouse, the spouse living at home. And once that annuity is purchased, in fact, the day that we have the client write a check to the insurance company to purchase that annuity, and we have them use a cashier's check, simply because the date that check is made out by the bank is the date that money is out of their account for Medicaid purposes. And the next day, the spouse in the nursing home can be eligible for Medicaid. So, now I mentioned that the chief reason that we can't help people who call is typically that if there's an incapacitated parent or spouse and no power of attorney or power of attorney with no gifting authority, that's when we may not be able to help at all. But I would say in the more general picture, like 98% of all the people that could benefit from our services, or not just me, other elder law attorneys, we can't help for the simple reason that they never call. And I think, and that's why I want to try to emphasize this point tonight, I think the reason people don't call in a crisis situation is they already know that it's too late. They're thinking, I wish we'd done something years ago.